Court calls the case People versus Michael Hartwell.
It's still around against the township.
Oh, boy.
Okay, take your time. Take your time. Would it be easier for you to sit down?
Yeah, I would.
Okay,
Man. I had a stroke,
okay.
Um,
Take your time.
the thing about it was, my mother was supposed to have took care of me
Of this?
when I was in the hospital, and I didn't know if it was suspended.
Okay,
And then,
hold on. We'll get to this. Okay.
Yeah.
What are we doing in this?
Yes, Your Honor, Assistant Public Defender Natalie Payworth on behalf of Mr. Hartwell. Is my right? We are asking Mr. Hartwell believes his license is currently valid, Your Honor, and we are asking if
It is.
It is. Thank you. That he would like to take advantage of the potential offer made by Mr. Siller of double parking.
That is correct, Your Honor. Okay.
I thought they were gonna dismiss it because the license was not I paid for it. I thought they was gonna suspend it. I wanna fix it. I don't have money to be given out. I
Okay,
just paid $200 and some dollars the other week, out of my, and then these wants me to pay another $180. I don't have that kind of money all the time.
hang on a second. Okay.
Here. It shows how I'm paying. I don't have to sit. I'm got money to pay out all the time. I just moved up here, and I got a lot of things I have to take care of. So, anyway,
John, I'm just gonna move to dismiss.
Pardon?
He's got a valid license. You confirmed it. I'm just
You're
gonna
gonna move to dismiss?
I'm gonna move this.
Any objection?
Certainly no objection, Your Honor. Thank you. Thank you to both.
Sir, this case is dismissed.
thank you. I appreciate it. It's hard for me to get around. I have to have my vehicle once I can. It had to come all the way down here to the last courtroom. I'm like, wow, I gotta make it down there. And
Okay.
it was hard for me to get.
But you know what?
But thank you.
I'm so glad you made it down.
Thank you. I was in the hospital for 6 months. I couldn't walk, and I got up, and I'm getting around now. And thank you very much.
You're welcome.
Yeah. Yeah. Have a good day.
You do the same.
Yeah.
And while I got to thank you, Mr. Siller, for that.
I got all the way down this wall. It's a long way. Yeah.
Court calls the case People versus Michael Jones.
On behalf of Mr. Jones, seeking practice under MCR 8.120 under the supervision.
Started talking, got up there. She just started. She
I-
got up. She just started moving toward the podium, started just talking.
I was too excited to see you be on your.
Oh,
again
you were
here.
so excited, were you?
So
All right,
excited.
all right. Take a deep breath, slow down.
I got you.
You got it?
Yes, Your Honor.
Okay, start again.
Okay. Kerma Dadush on behalf of Mr. Jones seeking permission to practice under MCR 8.120 under the supervision of Davi Lebo.
Have you been before me before?
Yes, but under the prosecutor's
You
office.
were on their side.
I was now on this side.
Now you're on this side.
Yes, Your Honor. And passed my bar exam. Yeah. Thank you.
Remind me where you went to school.
Wayne,
Yeah, undergrad?
law. Oh, undergrad, UT Austin. Oh, sorry. I was like, what do you mean? UT Austin, Texas.
Where?
University of Texas. Austin.
That's right.
Yes.
That's right. You're a Texan.
Yes, sir.
I do remember that.
Mhm.
We like Texas. Not a lot, but we like it. Okay, permission to practice is granted.
Thank you, Your Honor. Please say your name for the record.
Michael Jones.
Your Honor, we are asking for an adjournment to continue plea negotiations
Aren't they
with
tough or well?
prosecution.
Did you fill out a green sheet?
Yes, Your Honor.
Oh, see, she's all set. Okay. That's a text in there. How much time did you need, Count?
A short adjournment should be okay. Yeah, we just have to talk to prosecution.
October 31st,
Thank you, Your Honor.
2024, 9 a.m. Bond will continue and counsel welcome back.
Thank you, Your Honor.
Thank you,
Come back on that side to do God's work. Anyway.
Well, Your Honor, Kerma Dadush, on behalf of Mr. Novak, seeking permission to practice under MCR 8.120.
Really? Hold it. So when she was here before, did she have to do that every time? And she didn't have to do it every time. So she thinks she's on this side. She's got to do it every time. But no, I'm not blaming you. Who's your supervising attorney?
You can blame me. We don't blame my
who's your
supervisor.
supervising
No, no.
attorney? No.
She'll
don't
take
even try.
responsibility. It's Alex.
So she didn't tell you?
And Judge
Just no,
Washington-
answer me. She didn't tell you, did she?
She did not tell me.
She
But
did.
I should have known. I was here. I've done this more than her in this courtroom, so I should have known.
So you're trying to take responsibility.
I am taking responsibility.
Then why do you need a supervising attorney? Yeah, I know, right?
Sworn in.
She's not gonna tell you how the game's played. All right, fine. I don't need it again. I give you
Thank you, Your
permission to
Honor.
practice. You're good.
Thank you, Your Honor.
Because they gave you 2 cases today. That's it?
That's it. They could have given me more. Just kidding.
You wanted more to do, didn't you?
They didn't know I've been here before.
No,
Maybe they
no.
thought
But
too.
they wanted, you want more than that.
I could do more than that.
What's up with that?
We all had like
What?
5 cases.
What's up with that? How come she doesn't get more? What?
didn't make that decision. They wanted to
Hold
go
on.
easy on.
Who made that decision? Okay, where are they? Oh, no, none of them are here. Okay, fine. No, okay, all right, we're good. All right, what are we doing in this case?
You're.
We're also, I think we're done here. No.
I was like, that's not where we were going with this. Your Honor, the phone number we have for the client is disconnected, but we were going to ask for an adjournment anyway. The prosecutor has to contact the victim's right advocate to get information and see what the victim wants to do on this. So if Your Honor would grant an adjournment for this case.
Oh.
No. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 10,000 cash surety. That warrant will issue immediately. Thank you.
Thank you.
They sent you up there without a client this time too. All right, I'll talk to her.
My fault.
No, it's not your fault. Not everything is your fault. It's her. Clerk.
The court session began with the calling of the case people versus Michael Hartwell. As the case was announced, it became immediately clear that Mr. Hartwell was not in the best physical condition. The judge, showing remarkable patience and compassion, told him to take his time and even offered him a seat to make him more comfortable. Mr. Hartwell, visibly struggling, began explaining his situation to the court. He stated that while he was hospitalized, his mother was supposed to have taken care of a matter related to his driver's license. Unfortunately, due to his medical condition and his time spent in the hospital, he was completely unaware that his license had been suspended. This lack of knowledge about the suspension formed the core of his defense in this case. The assistant public defender stepped forward on behalf of Mr. Hartwell and addressed the judge respectfully. She informed the court that Mr. Hartwell genuinely believed his license was currently valid at the time of the incident. Based on this belief, she requested that the court consider the offer made by Mr. Siller, which involved reducing the charge to a double parking violation, a significantly lesser offense compared to the original charge of driving with a suspended license. The prosecutor, Mr. Siller, confirmed that Mr. Hartwell's license had indeed been verified as valid and he raised no objection to the proposed reduction. Given this confirmation, the judge decided to move to dismiss the case entirely, rather than proceed with a reduced charge. The case against Michael Hartwell was officially dismissed, bringing great relief to the defendant following the dismissal. Mr. Hartwell expressed heartfelt gratitude to the judge and the court. He explained that it had been an incredibly difficult journey just to make it to the courthouse that day. He mentioned that he had been hospitalized for 6 months, and during that time he was unable to walk. He described the physical challenge of traveling all the way to the last courtroom in the building, saying it was extremely hard for him to get around. Despite all these difficulties, he managed to appear in court, and the judge acknowledged his effort warmly. The judge told him he was glad he made it and wished him well. It was a genuinely moving moment in the proceedings, highlighting the human side of the justice system where a judge's empathy can make a significant difference in a person's life. The court then moved on to the next case, People v. Jones. This case introduced a new and memorable character to the proceedings, a young law student named Mel Jones who was appearing in court under the supervision of her attorney, as permitted under MCR 8.120. However, before she could even formally introduce herself or request permission to practice, she jumped straight into speaking. The judge noticed this immediately and pointed out with a smile that she had simply walked up to the podium and started talking without waiting for the proper procedure. It was clear that Mel was extremely nervous and excited at the same time. The judge, rather than reprimanding her harshly, told her to take a deep breath, slow down, and start again. Reassuring her that he had her back, Mel composed herself and began again properly, introducing herself on behalf of Mr. Jones and requesting permission to practice under MCR 8.120 under the supervision of her supervising attorney. The judge asked if she had appeared before him previously, and she confirmed that she had, but previously she had been on the prosecutor's side. Now she had switched to the defense side, which the judge found interesting. He then asked her about passing the bar exam, and when she confirmed she had passed, the judge offered his congratulations warmly. He further asked where she had gone to school. She mentioned Wayne for undergrad and at Austin, the University of Texas, for law school. The judge made a lighthearted comment about Texas, saying they like Texas, not a lot, but we like it, which brought some humor to the courtroom. Permission to practice was officially granted, and Mel proceeded to request an adjournment to continue plea negotiations with the prosecution. She had all her paperwork in order, including the required green sheet, which the judge appreciated. The adjournment was granted until October 31, 2024 at 9 a.m., with bond continuing and a warm welcome extended to Mel as she began her career on the defense side. The third and final case of this session was People v. Novak, and once again Mel Jones appeared, this time representing Mr. Novak. However, this time she forgot to formally request permission to practice under MCR 8.120 before beginning to speak. The judge noticed this and brought it to her attention. A brief but entertaining exchange followed regarding whose responsibility it was to inform her of this requirement. Mel's supervising attorney stepped in and took the blame, saying it was his fault for not informing her. Mel, however, tried to take responsibility herself, saying that since she had been in this courtroom before, she should have known. The judge responded with a humorous remark. If she already knew how things worked, then why did she even need a supervising attorney? The courtroom shared a light moment over this, and the judge ultimately granted her informal permission to practice, saying she was good to go. The substantive matter of the Novak case, however, took a more serious turn. Mel informed the court that the phone number they had on file for their client, Mr. Novak, had been disconnected. Despite this, they had planned to request an adjournment anyway, as the prosecution needed to contact the victim's rights advocate to determine what the victim wanted to do in this matter. The judge listened to the request and made his ruling. Since the defendant had failed to appear in court, the judge set bond in the amount of $10,000 cash and ordered that a warrant be issued immediately for the defendant's arrest. It was a sharp contrast to the lighthearted atmosphere that had preceded it. serving as a reminder that while the courtroom can be a place of warmth and encouragement, it is ultimately a place where accountability is enforced and justice must be served. Overall, this court session was a fascinating blend of human emotion, legal procedure, and judicial wisdom. From a sick man finally getting his case dismissed after a long hospital stay, to a newly qualified lawyer nervously finding her footing in the courtroom, to a missing defendant facing serious consequences, the session captured the full range of what happens inside a courtroom every single day.